The final case this morning to come before the court is Bartick versus Lorain County Commissioners. Let's see, I think we're just a minute early. Is everybody ready, or do you need anybody else coming?
No.
Okay. All right. You each will have 15 minutes to present your argument. The appellant may reserve up to 5 minutes, as you know. And just let me know when you are introducing yourself, how much time you want. Please stand behind the podium, and we are recording it, and it will be on our YouTube channel, so keep your voices up, and do not mention the names of children or victims. Okay, we're ready to proceed.
Thank you, Your Honor. My name is Stephen Hanadel. I represent the appellant Joseph Bartick. I'd like to reserve 5 minutes for rebuttal. So this is the case originates where the city of North Ridgeville petitioned for a ditch, a drainage clean out in the ditch that runs right through Mr. Bartick's property in Eaton Township, right in the middle of it. And so this matter went to the county commissioners, and Mr. Bartick retained counsel and sought information from the county commissioners. You know, his concern was that with the nature of the easement that the county wished to put on his property, because he leases that land out for farming, and so he sought information and wanted to know, whether the easement alongside the ditch was going to be temporary or permanent. That was never answered. He wanted to know how wide the easement was going to be. That was never answered. And the county commissioners never confirmed in writing that there would be no assessments against his property. That they orally requested, the commissioners orally assured him that there would be no assessments, but that was never put in writing. And, so he was very concerned with, well, what's to say that they won't go back on their word years later and then suddenly just put an assessment on the property in regards to a future ditch clean out. And because the context of all this, that this ditch has never been maintained. This ditch goes back to the 1800s, and Bartick's father owned this property going back to the 1960s, and this ditch had never been cleaned out. And I don't think anybody disputes the fact that it does need to be cleaned out, but the question here is the effect on his property, and the fact that he didn't get the answers that he sought from the county commissioners. It impeded his ability to present his case to the county commissioners. And then when he appealed to the trial court, he asked for the ability to present new evidence and for a jury trial on damages. Now, the commissioners voted that there were no damages to his property as a result of the easement, but the revised code makes very...
Counsel,
sure.
Just let me clarify something. What did the board resolution say about, the assessment for the project? Was it against property owners or against the stormwater management district?
So I believe the commissioners stated that the project was being funded from another source. So that they were getting either a grant, and I can't remember from where, but it was outside money that was going to help pay for it. I think the concern is that it's the future, and and as far as it would, and yes, they orally assured him yes there'd be no assessments, but it was never confirmed in writing, and ultimately when it comes to legal profession, and things in writing are a lot more valuable than what's orally assured. So all he asked for is, hey, can I just have a document in writing that confirms that there will be no assessments against my property? And because, yes, there might be a grant that provides funding for the project, but from my client's standpoint, he's thinking to himself, well, what's to say that the county won't try to recoup their cost from him as a property owner? And same thing for any future projects as well, that any future ditch cleanouts and so on and so forth. And then the other question is, well, if they want to come back at a later time and clean the ditch out, or are they be able to just come and go as they please? And if so, that's going to tear up the land when it comes to construction equipment and ditch cleanout equipment. That would tear up any land that wouldn't be arable for farming. So these are all questions that he just wanted to have resolved at the commission hearing, the commissioner just would not give him that information. They just seemed to conduct the hearing in a very haphazard way. And so when he sought relief from the trial court, he's just simply asking, hey, can I present new evidence? And also, the statute explicitly authorizes the jury trial to determine damages. And this is sort of I cannot find any case law on this particular statutory provision as far as how it's interpreted, but I did cite case law about how we interpret statutes, and if it's plain and unambiguous, then the court has to sort of read it as is and apply it as is. And I think at the very bare minimum, he should have received a jury trial to determine whether there are any damages to his property as a result of the easement. And ultimately, his concern is that, and what he maintains is that this is a taking by the county, and if the taking, then he should be compensated for it. So that's ultimately just where does this go to? Like, what's the effect on the value of his property? Is it a taking? Is the easement temporary or permanent? And once those questions can get answered, then we can determine then, well, what's the damage to his property? What's the effect on his property's value? And that is something that the revised code explicitly states that he's entitled to have a jury determine. But the trial court just denied all that. The trial court did not allow him to present new evidence or have a jury trial, and that's why we're here today. So I'm asking you to reverse the trial court and remand so that he has an opportunity to present new evidence and have a jury trial to determine damages, because the commissioner hearing was ultimately very incomplete. They did talk about, oh, maybe we can continue this to another hearing, to another commissioner meeting, and be able to hear additional evidence and so on and so forth. But then for some reason they just decided, oh, let's just vote on this now and be done with it. And they didn't do enough. They didn't answer they didn't respond to his information request. And there was, I believe Commissioner Moore did express some heartfelt concern for Mr. Bartick, as a property owner, as to what the effect on his property would be. But then, even then, the commissioners, they just didn't follow through. They talked about, oh, maybe we should, do this again another day, but then just didn't follow through on it. And decide, let's just be done with this. We're gonna say, there's no damage to his property, and it's all zero, and we're just gonna move forward, and that's it. And his ability to present his case to the commissioner depended upon the information that he requested from them. And so the statute does make clear that when the commissioners don't allow him to fully present his case, then he's entitled to the trial court giving him an opportunity to present new evidence to make that case. And on top of that, separately, he's entitled to a jury trial to determine damages to his property. So there's no further question. I'll leave the balance for rebuttal, but I think ultimately what we're asking the court to do is just simply reverse and remand the trial court so that he's able to present new evidence and have a jury trial to determine what the damages are to his property as a result of the easement for the drainage ditch cleanup.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, I am Christopher Fortunato, newly hired Assistant Prosecuting Attorney for Lorain County. I would like to also recognize my colleague behind the bar, Ms. Catherine Perales, also of the Lorain County Prosecutor's Office. We're both in the Civil Division handling matters of this nature. With regard to the two issues here that were lodged in the brief, I believe then that probably for this court's use of precedent, Williams against City of Akron at 141 Ohio Appeals 3rd 724 2001 is instructive and helpful in terms of your resolving this matter. The standard of review from an appeal on from let's say a board of county commissioners or a similar type of agency that holds hearings of this nature and makes findings, and gives the losing party the ability to file an appeal to the Court of Common Pleas, is a de novo standard. But the de novo standard is limited in the sense because it's not on law and facts, it's on, strike that. The appeal, though, does not mean that you get to have a completely new trial, which would possibly produce duplicative testimony as well as new testimony. The Board of County Commissioners can rule one way, but at this level, because they are not a board of, or may not be lawyers, and certainly are not judges, the state statute gives the judge on appeal the power to substitute his or her judgment for the judgment of that board below, especially if there are errors, the way 6130 or Chapter 6131 expresses in terms of findings. And here the trial court had indicated that the commissioners did not err and that their decision was sufficient to pass muster on an appeal to the Court of Common Pleas, and that there was no need for further testimony. A Court of Common Pleas may hear testimony on things, especially the issues of whether this is a necessary type of project, and if the need outweighs the costs of things, as well as the damages that could go to a landowner who would have portions of his property taken away. In that issue, and I would indicate that there seemed to be a paucity of evidence in the record regarding that, outside of the county commissioner saying that there would be no damages, and the fact that the landowner did not bring forth anyone, say an engineer saying, well, if they're going to do this, if they're going to take this much land from him, and then you put on a certified real estate appraiser to say that amount of loss to the property will be this much, like our office does in Board of Tax Appeals cases that sometimes go as far as the 9th District. There was really a paucity of any type of evidence from the defense standpoint to contradict what the resolution and the action at the commissioner's level was trying to seek. Now,
Counsel, is there a transcript of that?
I'm trying to remember, there's a 900-page record of documents in it. I did not see a transcript as much as there was like minutes of, I think, of the commissioners, or if there was anyone, like a clerk, taking that type of thing. I did not see one in our file, in our matrix file, so I can't answer that completely for sure, but there could be an issue with regard to that. Because I would, from someone who's done more than just prosecuting in my career, I know that there could be issues of takings, and that kind of thing concerns me, especially I believe very much in the case that Justice Scalia wrote about 15 years ago at the Supreme Court. I think it was beachfront property that was diminished in its value because of the way they zoned it, something of that nature. And as a lawyer, I believe that landowners' rights to any loss of property should be addressed. I don't think either party really did that at the commissioner's level.
Well, that's the reason why I was asking, because if there's no transcript, it's hard to determine what really did happen. If adequate,
I agree.
if adequate time was given, or if, they were allowed to present evidence or anything.
I can see where the court is coming on that, but I'm sorry I wasn't
That's
able
okay.
to I will check that, and if I.
Well, we'll find out too when we go through the record, and obviously I'll ask the appellant when he gets back up on his rebuttal as well.
Okay,
And I know it's a de novo review, but I'm just wondering, because one of the arguments is obviously that they weren't given enough time or they weren't given the opportunity to present their evidence, and so that's why I was wondering about the transcript. Thank you.
all right. Now, and of course, at the common pleas level, the judge there is permitted to substitute his judgment for the judgment of the county commissioners, simply because of legal experience and as actually some of the things Your Honor just mentioned in your question to me, among other issues of that sort. But at this level, this court could not substitute its judgment for the judgment of the Court of Common Pleas. You'd have to show that any finding of abuse of discretion can only be made when no evidence exists to support the trial court's decision. There is a lot of evidence in the record, but it does not seem, at least at the common pleas level, that the court did its work, I think, in determining from the equitable issues that there was a need to do this. And given that there was no evidence in the record from either side really discussing issues of loss to the appellant, the argument could be seen waived. But I will argue in the alternative that in this case, if that has not happened, then if so, then the court would do a limited remand or a remand only on the issue of damages, giving the right to a jury trial for that specific position. I think they would have to file probably a jury demand on that if they hadn't done so. But it is the position of my colleague who had written this brief, who is coming back from leave next week, that there was no evidence or insufficient evidence for the trial court to be able to substitute his judgment as the appellant requests for the decision of the county commissioners in this matter. But I asked the court to review that issue and to see if this appeal is sustained in whole, but in the alternative, which I don't always argue that way, but in the alternative, if there's an issue regarding damages on this matter, then it would be the fact that possibly that would need to be remanded and tried before the trial court in this instance. So I thank the court for your opportunity in this matter, or for our opportunity in this matter. And if there are any further questions, I may resume my seat.
I don't believe so, thank you. And you have 5 minutes.
Okay, thank you, Your Honor. Yeah, I don't know if you've seen the record yet, but it is definitely a record that I'm not used to in doing appeals from trial court cases where there's an actual trial conducted. As opposing counsel stated, that the record is not a true transcript that's generated by a court reporter where it's all neatly laid out in legible print and page numbers and lines and everything. It's meeting minutes. These paragraphs are just giant blocks of small print. It was a very difficult record to parse through, much more difficult than a typical trial transcript. But I think that also speaks as to the lack of formality that took place with the commissioner's meeting, because after all, it's just a meeting. It wasn't a trial. It's not, it didn't have the formalities with the rules of evidence and that you would expect in a courtroom such as this with a judge on the bench. And I think the court should take into consideration, I mean, the opposing counsel stated that these commissioners, they're not, I mean, I don't know how many of them are actually lawyers, I don't think any of them are, and they're not judges, certainly either, so very informal proceeding, and I think the record does demonstrate it was very haphazardly done as far as, trying to address the issue that Mr. Bartick has, and ultimately, he does have a right of due process in all of this, and I don't think that was complied with.
Does the statute, I know both sides have indicated that there's not a lot of case law, if any, on either on 61, 31, 31, or 32, but do either statute talk in terms of a hearing before the Board of County Commissioners?
I didn't hear the last part that they talked about.
Does either statute talk about a hearing in front of the Board of County Commissioners?
No, I don't believe so. The statutory scheme, from what I can tell, does not give any specific, I mean, there's some general requirements with how the Board of Commissioners has to conduct themselves, but ultimately, I think the legislature, when they drafted this, contemplated that any defects or deficiencies that take place before the Board of Commissioners will get remedied by the trial court, and I think that's contemplated by the fact that the statutory scheme gives the trial court de novo standard of review, to where the trial court is allowed to substitute its own view for that of the county commissioners. And that's where the trial court failed in this. So the statutory scheme takes into account that the commissioner's meeting is going to be informal as compared to a courtroom proceeding, and I think the legislature perhaps figured that they make up for that by giving the trial court full de novo review authority and the ability to substitute their own view, the ability to take in new evidence, and really make sure that the record is complete and that the due process rights of the parties are honored. And so that way, if it were to reach this court, you would have a nice record to be able to parse through and review. There were no hearings on the record conducted in the trial court. It's all briefing, so there's no transcripts from any trial court proceedings. All you have are the meeting minutes and then just the briefing in the trial court. So, given that there's not a lot of case law, I think that the court's going to have to review the statutes and resort to the case law that dictates on how statutes are interpreted by the court. But I think the statute about the right to a jury trial, I think is very plain, very unambiguous. I think that one's, in my opinion, a no-brainer. And now, as far as the statute in which the trial court takes additional evidence, there are some factors involved in that. And our contention is that the fact that the Board of Commissioners did not provide Mr. Bartick the information he requested, that impeded his ability to fully present his case to the board. And we're talking in terms of any expert witnesses, appraisals, dollar amounts for what he would claim are his damages. I mean, he can't come up with a dollar figure and argue, hey, my property value is declined by either $50,000 or $100,000 or what have you, without the information that he requested from the county commissioners. So I think there's as much as this is sort of a case, it's definitely different from the typical case that comes here, but I think this just has to be sent back to trial court. There's more that has to be done to really develop this record and really make sure that all the issues are meted out and we get a fair and just outcome.
Counsel, you're out of time, but I want to just address this to both of you. It sounds like the issues that you're alleging, appellant, is who pays. I want some kind of guarantee that I'm not going to have to pay. Permanent or temporary easement, and then compensation for any possible damages. But I don't see that you have engaged in any mediation.
That's correct. I don't remember what I checked in the document statement, because I know there's that question, and I honestly don't remember if I checked yes or maybe.
But it seems like the questions you're asking are not difficult ones, so that's what I was wondering about. So we'll talk with the other judges, but you might be getting a call from a mediator too.
Okay.
Thank you very much, both of you, for your presentations. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as you can look on the Supreme Court website for our electronic submission. So court is adjourned.